Good morning and good afternoon, everyone. It's now noon. Welcome. I see we have most of our audience here waiting for a few more people to join. So during that time that they're all joining, I'll go through a couple of notes. Again, welcome everyone. I'm Stephanie Jessamine. I'm Connect's business manager. And just as a side note, Connect is celebrating its 30th year. So thanks for being a strong participant and member at our events over the years. And welcome to today's webinar, Tariff Mitigation and Management. It's presented by Matthew Bach, who's an attorney at Middleton and Schrull, and who specializes in customs and international trade law and import, export, and sanctions regulatory compliance. Before we get started, I'd like to thank today's webinar sponsors, who are also Connect partners, Roanoke and Kerry Apex. Today's webinar is approved for 1.5 continuing education points through NCB FAA. If you've not provided your NEI number during the registration process, please follow up with Susan Beeland. I'll put her email in the chat shortly, and just check that your number is in the system so that you can get your points for this. Let's see. So I want everyone just to bring up a couple of points on upcoming events. Mark your calendar. Next month, which is just a week or so away, March 9th and 10th. March 9th and 10th, Connect will be having a forced labor webinar. Paula Conley will be presenting and participating in that. So keep an eye out for future notices from Connect, and registration will open shortly for that. Matt will take questions throughout the presentation. Just I know that we can't see you and we can't hear you, so please just type your questions in the chat and I'll present those to Matt as we go through the presentation. The webinar is being recorded and will be sent out later today. And in a separate email, we will send out the PowerPoint presentation slides as well. So with that, those are my housekeeping notes. I will turn this over to Matthew for today's presentation.
Thanks, Stephanie, and thanks to Connect for allowing me to present today. Like Stephanie said, I welcome questions throughout. We have an hour and a half, and I think I have plenty of materials to get through that hour and a half, but it might be nice to break it up a little bit with some questions. And I'll certainly try and break it up with some anecdotes as well. So let's get started. So the topic today is tariff mitigation and management in a volatile trade climate. So here's sort of the agenda that I want to talk about today. Just briefly setting the scene for why this topic is critical, has been critical for some time now. And then we'll go over some basic customs law principles that need to be applied and kept in mind as you consider and pursue some of the strategies that we'll talk about. And then we'll talk about some of the strategies. First, what I'm calling pre-importation strategies, and those are strategies that address, things you can do before the product hits U.S. shores, essentially, to minimize the application and impact of tariffs and duties broadly, and then post-importation duty relief strategies, things you can do post-importation to mitigate the impact of duties and tariffs. So setting the scene, I think most of you on the webinar either serve the community who's involved in trade or are part of that community. And so, this is nothing new to you. And perhaps you're joining this because you're feeling the impact of this scene right now. But there's sort of been a perfect storm for importers and companies engaged in trade generally, starting with the Section 301 China tariffs, and the Section 232 tariffs. These have been around for a while now, but continue to have a substantial impact on U.S. importers. As a recollection, there are 4 active lists of 301 tariffs, 1, 2, 3, and 4A. 4B was proposed, but never actually came to fruition. And tariffs there range from 25% for the first 3 lists to 7.5% for that list 4A. Section 232 tariffs, again, have been around now for coming up on 4 years, but continue to have an impact though a bit less so now that there has been some relaxation of US-EU 232 tariffs. But we'll talk about some of that. And then, of course, something we won't really get into today, but the costs and impact of supply chain disruption have certainly also driven importers to consider how they can elsewhere address costs. And so even if you're coming to this to try and recoup costs that you're feeling on the freight and supply chain side, that certainly has driven the value of looking at tariff mitigation. So some of the basic customs law principles to bear in mind. Of course, we want to actively consider opportunities for tariff mitigation and avoidance, but certainly always doing so with customs laws and regulations in mind. So this may be familiar to some of you, but pre-1994, importers were required to essentially just provide CBP was tasked with coming up with the value classification and origin data and all the other import data that we now supply. Whereas post 94, Congress passed the MOD Act, was essentially passed the burden over from customs to importers in a sort of honor system to come up with providing CBP with this data. And with that shift, with the shift to the importer having to act with reasonable care in supplying this information and this data to CBP, came some guiding principles. So the reasonable care standard that requires importers to provide this data to CBP comes with consequences for the failure to use reasonable care in doing so. And these are generally laid out in 19 U.S.C. 1592 and in the applicable CBP regs. But it essentially provides for penalties at various levels of culpability for making for declaring false information or omitting information that you should have provided to CBP. And it provides CBP with fairly broad authority to pursue past duties and civil penalties for up to 5 years from the date of entry. And as I said, there are 3 degrees of culpability. The first is simple negligence, and in the case of the omission of information or the provision of incorrect information, it veers towards near strict liability here, in that it's difficult to overcome one of these simple negligence penalties, without being able to point to the coming from a clerical error. So at the simple negligence stage, penalties can range from 2 times the duties due, or if duties are not due, if it's a duty-free shipment, 2 times the duties that would have been due, or 20% of the value, rather. Sorry. At the gross negligence stage, that moves to 4 times the duties due, or 40%. And at the fraud stage, that moves up to the full domestic value of the entered merchandise. So you can see, not only on a per shipment basis could these penalties quickly become prohibitive, but if it gives CBP an opportunity to look at 5 years worth of entries and apply these civil penalty standards against the full universe of entries, it can be quickly become prohibitive. So let's get into how customs determines what duties are due. So a customs duty is a tariff or tax that is imposed on goods when goods are transported across a border. And they can be either ad valorem, meaning a percentage of the value of imported items, or specific, meaning that the duty is computed based on the physical quantity of an imported item. Most tariffs, both in the US and globally, are ad valorem. And the formula for computing duties is fairly simple and straightforward. It's simply a matter of computing the value times the tariff rate. And in this case, or in all cases, the tariff rate is really just a function of the classification of the imported merchandise and the country of origin of that merchandise. Bearing in mind that, when we're talking about multiple levels of duties or tariffs, there's a compounding effect, right? So that tariff rate could be not only an underlying base MFN duty rate, but also anti-dumping and countervailing duties. And in this case, or one of the cases we're going to talk about a lot today, Section 301 tariffs as well. So you can see that in looking at this formula, and we'll talk about this at length, you start to see some of the areas at which minimizing a variable can have a big impact on the outcome. And the formula also helps to illustrate for the primary areas that I'm going to be talking about today. And that is classification, valuation, country of origin, and what I'm referring to as duty relief. And those are sort of the opportunities for post-importation mitigation. So let's look at classification strategies. The harmonized tariff schedule classification of a product is going to dictate the applicable rate of duty that's applied on at the time of importation into the U.S. And it's very much a key factor in determining also whether the product is subject to quotas, restraints, embargoes, and other restrictions. Vis-a-vis the topic of today, tariff mitigation, it's absolutely critical to determining both what the underlying duty rate is, but also whether or not it's entitled to special tariff preferences, i.e. The generalized system of preferences or a specific FTA, or also whether it's subject to enhanced tariff measures like Section 301. And there are a number of ways that we can look at classification as a mechanism for tariff mitigation. The first one I want to talk about today is the idea of tariff engineering. So where differences in customs duty rates are applicable to similar products, this creates an opportunity for imported records to modify the design of an imported product to reduce customs duties associated therewith. So what this means is where, if you look at the harmonized tariffs code, and some of you may have looked at this, for very comparable products with very minor design or engineering differences, the code can sometimes offer up starkly different duty rates. So if you can identify an alternative and reasonable code that still accurately describes your product, and that only requires a minor shift in the way the product is designed, manufactured, assembled, et cetera, you could potentially identify a separate provision for classifying your product and moving into a much more amenable tariff code. And though this does sound like a bit of a loophole, tariff engineering is very much legal and is authorized so long as there is no deception or fraud. And this has been reinforced at length, including all the way up to the Supreme Court in the US v. Citroën case, where the court held that classification of imported merchandise must be ascertained by an examination of the imported article itself and the condition it is imported. So long as at the time of importation, the product as designed, assembled, manufactured, built, aligns with the proposed code that you're using, CBP is required to examine it on its face and see whether or not it conforms with that provision. There are some limitations, and in the court, in this case, the court said it just cannot be used essentially as a disguise or artifice. And we'll talk about some examples of disguise or artifice. So what are some successful examples of tariff engineering? One of the most famous cases, and one that's often mentioned because it offers such a stark contrast. Converse sneakers include felt on the bottom, and this simple addition moved the sneakers from a 37.5% code to a 3% code. Tariff engineering is fairly common in the apparel and textile space, where there are so many different codes for comparable products, and simply amending the blend of textiles for a garment can move you into lower duty rates. Some examples of unsuccessful tariff engineering, and this would be an example of a disguise or artifice, is an importer of feather dusters, disassembling them post-importation and using the feathers to make apparel. This would obviously require CBP garnering information on this happening post-importation, which could occur through various means, either competitors or a disgruntled employee. But to the extent you're really just bringing something in as a disguise, and then breaking the product down and using it to build something that would have otherwise been tariffed at a higher rate, you certainly would risk CBP and the courts eventually determining that this was done artificially. So tariff engineering, broadly speaking, as you'll see today, this is sort of a mile wide and an inch deep presentation. We could spend an hour talking about the ins and outs of tariff engineering, but I think the bottom line there is, as with all the classification topics that we'll talk about, take a look at your full list of SKUs and your full list of classification codes, determine which are subject to high duty rates, and determine whether or not with your engineers or your product development teams, there are potentially alternative reasonable codes that could be leveraged with minor modifications to the products themselves. So moving beyond tariff engineering, looking at, okay, you can't change the nature of the product, or you can't make any slight modifications to get it into new codes. Are there simple, reasonable alternatives based on the nature, form, function of your product as is? Or in other words, have you potentially been using an incorrect code that may seem reasonable, but perhaps there's another reasonable alternative? And this was certainly very prevalent in the early lists of Section 301, where when that first list came out, most of the preliminary calls from clients were, my product is classified in our code that's on list 1. Is there an alternative that I can use to get off that list? And so that was a lot of the preliminary tariff mitigation work under 301 involved really digging into products and their design and form and function, and helping clients try to arrive at an alternative that would either pass muster with customs, or that we could include in a ruling request with customs to get their approval on it.
Matt, I have a
Yep.
question.
Okay.
Someone's asking if tariff engineering applies to fabric imports.
Yeah, I mean, it really applies across the board, assuming you can look at potentially applicable codes to a minor revision to your fabric. If you look at the tariff code, again, for things like apparel and textiles, there are a lot of different codes for products that are certainly objectively quite comparable. So I would start with the provisions that are in or near yours in the tariff, and identifying whether or not there are potentially reasonable alternatives based on, again, minor derivations to the assembly process.
And it does look like I have the ability to allow people to speak individually. So if someone does have a question that they'd like to ask directly, you can type that in the chat, and then I will just toggle you to talk and you can present your questions.
Yeah. So again, the other thing. Okay, sorry. The other thing about this reasonable alternative analysis is that, again, particularly in the earlier days of the application of 301, It also presented some instances in which, clients who had otherwise had a rate that was low were happy with the rate, or a free rate were happy with the rate. And so we're actually unaware that that rate was probably not reasonable, or that code was probably not reasonable rather. And so the exercise of verifying whether or not there's an optimum alternative in some cases can lead to a conclusion that you've been using the incorrect code, in which case, in addition to moving to the other code for tariff mitigation purposes, could potentially lead to the decision to make a prior disclosure to customs about the reasonability of your historical classifications. In any case, beyond tariff engineering, again, look to your codes, look to see if there are reasonable alternatives. Use service providers to support your internal conclusions, whether it's a customs attorney or a customs broker or a consultant. The CBP and courts have agreed that you can meet your reasonable care standard by relying on the advice and guidance of a subject matter expert. Failing some level of internal comfort around your internal classification decisions, CBP offers a binding tariff classification opportunity. Classification rulings are turned around really quickly as far as a government service is concerned. You usually have responses in 30 to 45 days. So assuming you have some timeline, I would and are struggling to arrive at a level of comfort around classification, you should certainly explore the binding tariff ruling process. So in addition to tariff engineering and simply looking at alternative codes that might offer relief, with regard to Section 301 tariff specifically, if you can look to apply one of the Chapter 98 special provisions to your products, Section 301 tariffs do not apply to products for which an entry is claimed under most headings, subheadings of Chapter 98. So these would, yeah.
Apologies. I do have a follow-up question on that, I believe. I think you may have gone ahead, but the question is, are there recommendations for customs, brokers, attorneys, consultants to work with? Are there any recommendations? They can't hear me.
Yeah, okay. Yeah, so I can see the chat now too. So the question is, are there recommendations for customs brokers, attorneys, consultants to work with? I mean, I could think of one I'd recommend. There are others on this call who are certainly qualified. I think reaching out to Connect can probably offer you a list of brokers, attorneys, and consultants that are members of Connect that could certainly help. But there are many. I think really the only qualification here is vetting that they do in fact appear to be a custom subject matter expert. So returning to the Chapter 98, this has offered a lot of relief for clients as well, where you can't engineer the product into a new code. There are apparently no reasonable alternatives, but if your product falls within a category to which one of the Chapter 98 headings or subheadings may apply, by default of entering your products using one of those headings or subheadings, you can also avoid the Section 301 tariffs. And there are many examples of this. The most common are American goods return provisions, or the return of goods that were previously exported without being advanced in value. And so this doesn't change the underlying classification of your product. This is a supplemental classification that confers not only usually duty-free entry in and of itself, but also allows you to avoid the application of the 301 tariffs. Sorry, one second. So again, if you can't leverage some of the other classification opportunities, look to see if there may be a Chapter 98 heading or subheading that applies to your products. Again, obviously, if you're returning U.S. goods, or returning goods that were previously imported and then exported. Those are opportunities. Others that are a bit more, or that were at least a bit more obscure, but have been used much more prominently, are things like the agricultural use exemption, where to the extent you can demonstrate that your products are being imported and actually used at some point post-importation in a horticultural or agricultural use, and so long as you make that designation at the time of entry, you can obtain relief from the Section 301 tariffs. Bear in mind, as many of you may know, a lot of these Chapter 98 provisions, or for that matter, any provision where customs is actually losing revenue, or you're avoiding paying revenue to customs, these provisions are going to have fairly detailed documentary support requirements. So make sure you understand what's needed before you make a declaration, and then make sure that you make a declaration timely. So let's move on to country of origin strategies. Unless there are any quick questions on classification before we move on.
No, I don't see any questions at the moment, Matt.
Okay. So as a reminder, the reasonable care obligation requires importers of record to make accurate declarations as to the country of origin of imported merchandise. And the issue, or one of the issues with country of origin declarations and the reasonability standard is, these determinations can range from very simple and straightforward, where you're talking about raw materials that obviously are originating in a country, but can be quite complex, where you're talking about complex machinery or other items that involve inputs and assembly in multiple jurisdictions and countries. The nice thing is that some of the complexity here offers relief, in that if you can leverage the complexity in your favor and confer an origin other than, say, China on your product, you can essentially avoid tariffs that are applicable based on the original origin. So different country of origin rules apply for determining the origin of a product based on whether it's coming from a country with which the U.S. has a free trade agreement or some other tariff preference program, or whether it's coming from a country with which the U.S. does not have such a program. And we'll talk about briefly, we'll talk about preferential versus non-preferential rules of origin. So as I mentioned, the complexity here does sometimes lend itself to an opportunity for mitigation. So with regard to the 301 tariff specifically, these are origin-specific tariffs that only apply if your product is of Chinese origin. And so to the extent you can determine or find an opportunity to change your product in a third country and confer that third country origin on your product pre-importation, you can avoid the China tariffs. Alternatively, if your product is being exported from China to the U.S. But incorporates non-Chinese components that can be determined to be those components that lend their essential character to the finished item. And if those components which lend the essential character are, say, Taiwanese in origin and are not substantially transformed in China during the assembly or manufacturing process there, they would essentially, those essential character components would lend the origin to the finished item. So one of the classic examples here is in the bike or e-bike realm, where you can take a Taiwanese bike frame, and CBP has said repeatedly that bike frame is the item that lends the essential character to a bike. So you can take a Taiwanese bike frame to China and assemble a fully functional bike in China with all other components being of Chinese origin, including for e-bikes, battery cells and all the machinery. And that bike will remain a Taiwanese bike because of the origin of the frame. It's not always that straightforward. Sometimes you can get lucky and you can find a ruling where CBP has made that kind of a bright line rule stating that this component for these items is the item that lends it its essential character. In other cases, you really have to dig into the product with your product engineers and designers and make a case for why X component coming from Y country is the item that lends the finished product its essential character. And since that item is not substantially transformed in China, the full item remains the origin of that item. Obviously, as you can see, this requires some analysis and some insight. And again, is another ripe opportunity for a ruling request to customs. This is not, even more so than the classification realm, I think this is not an area that you would want to make a significant change to the origin of your products without first either really getting comfortable and getting an opinion from a lawyer or subject matter expert, but also potentially getting a ruling from customs. So beyond simply avoiding, China origin and Section 301 tariffs, the rules for origin can vary, as I said, significantly between non-preferential rules and preferential rules. So under non-preferential rules of origin, and again, this is where there is no FTA or preferential scheme applying. There's a wholly obtained criterion. This again is for things that are obviously the growth, product, or manufacture of a single particular country. And then there's the idea of substantial transformation, which I mentioned in talking about 301. So this is where goods are coming from more than one country and are being assembled in a country, and you're really trying to determine whether or not that assembly or manufacturing or processing process in the final country of assembly confers origin by substantially transforming the components from diverse jurisdictions. And this is not a straightforward test. It's a test that's applied on a case-by-case basis. And it really looks to see whether or not the product that emerges from the manufacturing process is one that has a new name, character, or use. So as you're considering your assembly process and your supply chain, you need to be considering a number of elements, including which items in your costed bill of materials lend the product its essential character. And is the manufacturing process that's occurring in the final country in which the good is produced one that classifies, or that qualifies rather, as substantial transformation? Turning to preferential rules of origin, there's still the same idea of wholly obtained. So goods that are produced in a single stage or wholly obtained in a preferential trade partner country. This is clear and obvious usually, and requires little proof to demonstrate origin. The more complex issues arise where you're dealing with products that incorporate components from diverse jurisdictions. And in that case, if you're trying to leverage the specific rules of origin of a free trade agreement to qualify your finished good for duty-free entry or reduced duty entry, you have to look at the very specific rules of origin in that FTA or whatever program you're leveraging to determine what rules apply to your product. And there are usually three main methods across most FTAs for how an item can be determined to be qualifying under that FTA. And it's usually one or a combination of these three methods. The first is a change in tariff classification, or the tariff shift method. This is where, by virtue of the processing activity, the resulting good is in a different classification. And it's usually at a heading basis, but sometimes it's at a subheading basis. Whether you're incorporating a sufficient amount of regional value content, or whether or not the specific manufacturing process that you're undertaking confers origin. And again, most FTAs incorporate all three of these. And in some cases, the rule of origin for a specific product can incorporate more than one of these rules in order to confer origin. And just before we stop talking about country of origin, there are cases, and this is sort of another layer of complexity, but I've seen this as recently as last week, where you have a company that traditionally has been a Taiwanese manufacturer who relies heavily on Chinese factories as to finish their goods. And so, although there are some Taiwanese components, the bulk of the components are coming from China, and final assembly is in China. And so, you know, in looking at opportunities for avoiding China tariffs, clients could potentially entertain the idea of setting up a subsidiary entity in a jurisdiction like Mexico, where the thought process is we're going to take our assembly process that's now occurring in China and do that in Mexico and try and qualify for USMCA. That's a big shift in the supply chain. It comes with substantial costs, and you would really have to determine in advance of doing that whether or not the proposed assembly and manufacture in Mexico confers origin. And you know, there are also instances in which, and I've seen this recently as well, you know, a client has gone to the trouble of trying to move production to Mexico, but for some reason or another is failing in a USMCA qualification process. Because of the distinction between USMCA qualification and, for instance, the idea of substantial transformation as a method for conferring origin for purposes of duty and marking. Again, there's a distinction between duty and marking and, you know, a specific FTA qualification. You have situations in which those goods that were transformed to some extent in Mexico will not qualify for Mexican origin for duty-free entry under USMCA, but do meet that substantial transformation test for purposes of not only a marking, but for avoidance of Section 301 tariffs. So, you know, to the extent you're in a jurisdiction where an FTA may apply, just because you have failed to qualify for FTA privileges, don't forget that you may still be qualifying under the substantial transformation test for non-preferential rules of origin for avoidance of things like Section 301 tariffs. I realize that was convoluted, so certainly happy to deconstruct that offline. So just as a recap on countries of origin strategies, really look at based on the products you're importing and where they're imported, whether or not there are preferential or non-preferential rules of origin that permit you know, permit you to declare an origin that is subject to less tariffs in the U.S. or less duties rather. Sorry, there was a question from an attendee that could these country of origin strategies apply to raw materials? Again, fabric is tricky because, you know, it certainly is considered by some to be a raw material, but there are, you know, raw material components of fabric, right? So it is certainly closer to the raw state than a complex machine would be. So there may be opportunities for you to leverage country of origin rules to consider alternative origins of fabric, but you're probably going to have less opportunities than someone with a more complex product would have. But yeah, so I would look at, you know, where your yarn is coming from, and depending on the jurisdiction in which you're you know, making fabric, what rules of origin apply to confer origin on that process. So next we'll talk about some valuation strategies. And classification and country of origin offer their own complexities. To me, I think valuation can be one of the more complex areas of customs law. And so with that complexity, though, I think you do have a number of opportunities for less avoidance of tariffs, but mitigation of tariffs, certainly. So returning to that basic duty formula that we looked at, proper valuation is critical because most duty rates and all of the recent tariffs that we've been talking about are ad valorem, meaning they're a percentage of the value of the entered item. So U.S. law sets forth the rules for valuing imported merchandise, and these implement the WTO valuation agreement. So properly understanding and applying customs valuation rules will generally allow the importer record to not only comply with the laws and meet that reasonable care standard, but can also offer an opportunity to minimize the dutiable value of imported merchandise. So two of the key mitigation strategies that importers have, and that I'll talk about today, are identifying costs that can potentially be deducted or unbundled from the declared price. And then I also want to talk about the use of first sale. So I won't go into too much, of the regulatory background, but I think it is worth considering, or at least reviewing, some of the methods of appraisement and where some of these opportunities arise. So there are 6 customs-approved methods of appraisement, and these are in hierarchical order, meaning this is the order in which you, as the importer, are required to consider the application of these methods. The first is the transaction value, and that's simply the price actually paid or payable for the imported good. And as you can imagine, this applies in the overwhelming cases of entries, both for related party and third party transactions. The second is the transaction value of identical merchandise. The third is the transaction value of similar merchandise, followed by the deductive value method, the computed value method, and the fallback method. I won't get into a lot of these methods today, and we're going to focus on opportunities arising out of the transaction value method, because it is really the core of where most import valuation occurs. Sorry, there's a question from the audience. How would you identify proper value of materials used for research in clinical trials? This is something we probably want to take offline, and I'm happy to. But this is sort of where, ironically, you would be moving out of the transaction value area that I just talked about, and where a lot of these other methods would not apply. You would arrive at some sort of a reasonable fallback method of attempting to assign a fair market value of R&D materials. But we can talk about that offline if you'd like. So again, the focus today will be on value engineering opportunities within the transaction value arena. So again, transaction value is defined as the price actually paid or payable for the merchandise when sold for exportation to the U.S. There are statutory additions to that price. These would include packing costs incurred by the buyer, selling commissions incurred by the buyer, the value of any assists, and an assist is anything that you as the importer are providing to the supplier that is of value, either free or at a reduced cost. You also have to add back into the price paid any royalty or licensing fee that the buyer is required to pay directly or indirectly as a condition of sale. And you also have to provide or build back into the price actually paid or payable the proceeds of any subsequent resale, disposal, or use of the merchandise that accrue to the seller. So the overarching goal here being to make sure that the price you pay, or the price you declare rather, to customs at the time of entry it is equivalent to any payment that essentially flows back to the seller and that is linked to that specific imported item. And because of the goal of transaction value, there is a presumption by Customs and Border Protection that any payment made to a buyer, from a buyer to a seller, or a party related to the seller, should be part of that price actually paid or payable. But that presumption is rebuttable in that there are some payments made by the buyer to either the seller or parties related to the seller that can be unbundled from the transaction value, or that don't need to be added into the transaction value. And the two big areas that I want to talk about today are bona fide buying agency fees or commissions, and royalties and license fees, including exclusivity fees. All right, so the first area of opportunity for, again, here we're not avoiding tariffs, we're trying to minimize the value against which the tariffs apply. So the first opportunity here is figuring out how something qualifies as a buying commission, and how you can make sure to deduct that commission or the value thereof from the declared price at the time of importation. So in contrast to selling commissions, buying commissions are not one of the specified additions to the price actually paid or payable. And no addition is to be made for a bona fide buying commission to the price declared at the time of importation. The one caveat there is, if that buying commission is built into the total payment to the seller, meaning, there's no separate line item and there's no separate payment linked to the buying commission, you're not going to be able to unbundle that. Customs will say that that is part of the price actually paid or payable. So as we go through this, if it looks to you like you may have costs linked to buying agency commissions, but that right now that is part and parcel of your payment to your seller, you should be considering how you can separately pay that item. So like with many things, there are no hardline rules with regard to identifying what constitutes a bona fide buying agency fee. And this is really looked at on a case-by-case based on a totality of the evidence. There are really no single factors that are determinative either, including, you can have a buying agency agreement with an entity that you call a buying agent. But if from Customs perspective, the relationship and the actual activities do not align with the bona fide buying agent, those fees would not be deductible. And what CBP looks at really is that relationship. They want to make sure that the principal in that relationship is the importer or the buyer, and that the buyer is really directing the activities of the agent, and that those agent activities are really taken for the benefit of the principal buyer. That said, if you go through the analysis and if you identify activities that are being compensated that appear to be bona fide buying agency services, those fees should absolutely be deducted from your transaction value. And again, if they're currently being rolled up into the some portion of the price paid, you should look to unbundle those going forward and pay them separately. This isn't something that you could necessarily do retroactively, right? Because you would have documentation showing a single line item payment. So it's something that going forward, you should look to split out your buying agency fees and really highlight the independency thereof. The next area for tariff mitigation is looking at reducing the value against which the tariffs apply, again by unbundling royalties and license fees from the total payment. And this is an area that's a bit trickier than bona fide agency fees, and that really requires that you look at what is being paid for, and whether or not the payment, well, two things: whether or not the imported product is extrinsically linked to the IP for which a royalty or license fee is owed, and whether or not that product could be imported without making that payment. So unlike some other opportunities, there is somewhat of a test here, though the test in application is not necessarily straightforward. So I'll skip ahead to that test. So CBP has articulated 3 factors that assist importers in determining whether or not royalty or license fees that are part of a transaction value can be deducted therefrom, or whether or not they should be added thereto. So the 3-part test is: was imported merchandise manufactured under patent? Second item: was the royalty involved in the production or sale of the imported merchandise? And could the importer buy product without paying a fee? And the way they've set up this test is affirmative answers to the first and second questions, and a negative answer to the third question points toward dutiability. Now that means that, you know, if you don't have 2 no's and a yes, or you have some other combination of no's and yeses, you're really going to have to make an independent determination as to whether or not you think you can reasonably conclude that you know, the royalty or license fee can be deducted. But at least in this case, there is some you know, preliminary test for determining whether or not the royalty or license fee you're proposing to unbundle can be unbundled. And as an example, I wanted to talk about exclusivity fees. And again, a lot of these topics came up as importers look to avoid 301 tariffs, right? They ran through the classifications. They determined they couldn't change the classification to any other reasonable alternative. They had looked at origin and determined there really was nowhere else that they could produce their product to avoid tariffs. And so the opportunities then arose to look at the agreements that they had with their sellers or with parties related to the seller to see if, you know, any portion of the payments made could potentially be unbundled. And in certain cases, albeit limited cases, there were fees like the exclusivity fee that offered an opportunity to extricate the value of that exclusivity fee from the current transaction value paid. And why is that possible? Well, because if you look at the 3-part test, and remember that we are looking for 2 no's and a yes, an exclusivity fee seems to meet the test. Because under an exclusivity fee, royalties are not related to the imported product's manufacturing process. There's certainly no patent, or you're certainly not paying for the patent. Royalties, the exclusivity fee is not involved in the production or sale for exportation. It's rather simply a right to sell after importation. And the importer could buy the product without paying the fee, in that exclusivity fee is not inextricably intertwined with imported products. It's more based on a geographic market or volume restrictions. Sorry, not volume restrictions. So that's just one example of you know, one of an innumerable number of royalty or license fees or fees that fall within the royalty or license category that could potentially be unbundled from your transaction value. Again, this requires, you know, a fairly in-depth analysis of the agreements between the 2 parties, or potentially more than 2 parties, and an understanding of how to ensure that you demonstrate reasonability in reducing the value of imported items. And again, as with all the topics discussed today, you know, CBP has fairly good data analytics. They can fairly quickly note a change to your classification, origin, or value from your, you know, historical Hear me? Hello? Stephanie, can you hear me?
I can hear you, Matt. You're
Okay.
set. Thank you.
So just making sure that to the extent you're making a change that is certainly beneficial to you as the importer because you're going to avoid certain tariffs or duties. It's conversely of great interest to CBP and that they will be losing that revenue source. And so make sure that you have a very documented process by which you arrived at your reasonable conclusion. Let's move on to the topic of first sale. So unlike the idea of unbundling a fee from the price declared at the time of importation, the first sale method really looks at a specific category of import transactions, and that is multi-tiered transactions. And it's designed to offer an opportunity to the importer to not include in the price paid to customs or the price declared to customs the value of the markup paid to an intermediary. So this really came about, or was really common at least with Hong Kong trading companies that were sort of for a long time the only access that U.S. importers could get to mainland China factories. And so the idea was, to the extent the U.S. importer is paying, I'll continue to use the example of the Hong Kong trading company. To the extent the U.S. importer is paying the Hong Kong trading company, who is then going to China and paying a factory for the item that is sold directly to the U.S. importer in America. Customs has allowed or permitted this first sale idea that says we're going to allow the importer to declare the price paid by the trading company to the factory rather than the price paid by the importer to the trading company, essentially cutting out the importer, the intermediary entity's markup from that declared value. Again, as with anything, where there is a benefit to the importer, this is going to come with fairly steep documentary requirements, which we'll talk about. So in order to qualify for first sale, you have to demonstrate that there is a bona fide sale between the manufacturer and the middle entity, and between the middle entity and the importer. And by bona fide sale, CBP means there's a buyer and seller that are treating each other as such, meaning there's offer, acceptance, consideration, all the elements of a bona fide sale. And two, that at the time of first sale, goods were clearly destined for export to the US. So we need to make sure that those goods aren't flowing from, in the example, from China to Thailand, where they sit in a warehouse and are then unsold or moved to the US, right? It needs to be clear. It not only needs to flow directly from China to the US in that example, but it needs to have been clear to each party to that transaction that their goods were intended to go directly to the importer in the US. And then finally, the third element is that the sales price between the manufacturer and the middle entity needs to satisfy the arm's length standard. And really, this also applies to the sale between the importer and the manufacturer. But in most cases, some of the complexities arise around factories that are owned by the middle entities, and you're trying to work with both parties to make sure that that relationship satisfies CBP's arm's length standard. So who is this potentially valuable for? Well, certainly anybody that's in a multi-tiered transaction structure. But historically, it's been particularly interesting to companies in the textile, footwear, apparel, consumer goods, chemical, and plastics industries, these industries tend to operate in a structure or a model that is conducive to the use of first sale. And obviously, as with other things like foreign trade zones that we'll talk about, because of the documentary, and regulatory compliance hurdles or burden, it probably also is mostly interesting to companies that have, high duty burdens or heavy volume, where the application of this type of a program could really have a dramatic impact. So what are some of the difficulties in leveraging the first sale program? Obviously, substantiating and documenting arm's length pricing, where there is a related party relationship between two or more of the parties to that structure. Substantiating and documenting there's a bona fide sale, and in some instances, substantiating and documenting the clearly destined requirement. There are some minor allowances in the clearly destined requirement. I've seen cases where it was not defeated simply because the goods did transit through Hong Kong and were consolidated there. So long as they never left the custody of the consolidator, and otherwise the documents showed that all parties knew that the goods were flowing directly to the U.S. importer. And then the fourth burden really is, setting up and maintaining your program. A lot of importers or a lot of attorneys and consultants approach this somewhat, take different stances. It seems to me that there is a consensus that most consultants or attorneys recommend that you get some sort of at least tacit approval from customs in advance of launching into a first sale program. There's no rule process whereby customs will, grant you a binding ruling stating that by virtue of this model, you're guaranteed first sale. But customs will, generally speaking, if you approach the port in which you intend to transact, provide some feedback and sort of at least tacitly approve the proposed first sale valuation program. And so, if you're working with an attorney or consultant, make sure that you're also working with a good broker, since they'll be the ones doing the filings, and make sure that you have an open line of communication with customs. So we've talked about some of the pre-importation strategies. Let's talk about some of the opportunities for duty relief on the not necessarily back end, but once the goods have actually come into the U.S. and you've made a duty declaration already. So the first opportunity for relief I want to talk about are foreign trade zones. I'll say in advance that this, while very much a good duty management tool, FTZs do not allow for 301 avoidance, right? So if you bring in goods that are subject to 301 and manipulate them in an FTZ, including by incorporating them into a manufactured item that is very much substantially transformed, you would still have to pay the 301 tariffs on those imported components. So, I'm going to say good things about FTZs and recommend them in some cases, but it's not a 301 avoidance tool. So an FTZ is an area that is physically located within the U.S., but that is considered outside of customs territory for customs purposes. So it's designed to increase the use of American labor and increase capital investment in the U.S. So very much has a U.S. Foreign policy aspect to it. It is certainly endorsed by the government as a mechanism for the benefits it confers. FTZs are authorized by the Foreign Trade Zones Act, and operate as a public utilities pursuant to grants from the Foreign Trade Zones Board. Operations are governed by both the Act and by regulations issued and enforced by Commerce and CBP. So it is, as we'll see, it's a tricky area, especially because you're dealing with authorization and enforcement by two distinct federal agencies. Both manufacturers and distributors can benefit from operating in FTZ, and businesses can import product into a zone without paying customs duties. And in addition to duty avoidance or delay, the FTZs offer a number of benefits to companies for which they are relevant. So first and foremost, obviously, relates to duties. Duties on products that are imported and either destroyed or exported are never owed, and they also offer a cash flow benefit in that duties are not owed until those goods that are imported into an FTZ are exported into U.S. commerce. So there's a potential temporary and/or permanent duty deferral for imported components, and in some cases that alone is worth it for some companies to consider FTZs. But they also offer other potentially material benefits. To the extent you're doing some manufacturing or processing in the zone and have approval to do that, there could potentially be an inverted tariff benefit where the tariff rate that applies to the finished item that leaves the zone into U.S. commerce is potentially lower than the tariff that would apply to the independent components that were imported into the zone and processed into that finished item. So if that's the case, if you're already taking, as an importer, if you're already intending to take imported components and manufacture them into something else in the U.S., there could be an opportunity to do that manufacturing within the confines of a foreign trade zone and only pay duties based on the rate applicable to that finished item rather than each individual component that you're importing. There are also logistics, broker, and MPF fees that may seem marginal when considered on a pre-importation or pre-shipment basis, but because of the way FTZs operate, and because you can do weekly consolidation of exits from the FTZ, you can essentially consolidate a lot of these pre-shipment logistics or broker fees and MPF fees into a single fee for the admission out of the zone into U.S. commerce. And if you're filing dozens of entries per week, each one of those entries would, absent the FTZ, trigger individual MPF fees up to the MPF limit, which is currently $528.33, and individual broker fees. And I've seen, for companies with high shipment volumes, this benefit, which may seem marginal, can amount to millions of dollars over the course of 5-10 years. In addition to these other benefits, in some states, Texas being a prominent one, FTZ users don't have to pay a state property tax on inventory that's sitting in a foreign trade zone on the date of taxation. So again, very much an added benefit, and in some cases, a very material benefit. If importers who have inventory that sits around for a while on a regular course can have that inventory sitting in an FTZ, you can avoid paying state or local inventory tax on that inventory. So aside from the benefits, which certainly seem great, there are some limitations and requirements associated with FTZs that can be burdensome. There's a geographic limitation, though, because of the way the geographic limitation is framed, because of some of the alternative site framework opportunities, just about every area in the U.S. is now open to the establishment of an FTZ zone or subzone. So how does one go about forming an FTZ. It's a multi-state process that again involves coordinating with at least 2 federal agencies. You have to get geographic approval from the FTZ board, and fees to apply there. You have to get approval from the Foreign Trade Zones Board if you're proposing to do production in the zone, which would extend the processing time of that application. And then once you get approval, geographic approval and or production approval from the FTZB, you then have to have CBP approve the site and activate the site for use. And sometimes coordinating between not only these 2 federal agencies, but the various municipal or local or state agencies that have a say in whether or not you get to set up an FTZ and or obtain the tax benefits that can be derived therefrom, can lead to lengthy application and FTZ formation timelines. I'd say, a best case scenario if you're not doing production activity is probably 3 to 4 months. But it can really go up from there. I had an FTZ client in Texas. It took us nearly 3 years to set up the FTZ. There were intervening issues like hurricanes and pandemics, but because you're coordinating with so many different parties, particularly where in this case they were trying to obtain a reduction of their state and local taxes. It can result in a long, lengthy, and sometimes costly exercise. And the FTZ is also somewhat unique in that. So sorry, there was a question. Am I understanding correctly that an FTZ can theoretically be set up in any state in the U.S.? Yes, that's correct. It's supposed to be within a specific drive or distance from a port of entry, but because there are so many ports of entries and ports of entries in every state, I think you'd be hard pressed to find an area in the U.S. in which you could not set up some form of an FTZ. The other complexity with FTZs is that you as the importer are not simply dealing directly with the federal agencies. That there are 4 separate parties to FTZ operations, though in some instances some of these parties can be the same entity. There's the grantee, which is essentially given the authorization from the FTZB, and is the party that deals principally with the Foreign Trade Zone or the Commerce Department. There's the operator who runs the zone, who manages the zone, and who deals with the grantee. And then there can be users. So, for instance, sometimes operators like 3PLs will own and run a zone, or on the land and run a zone, and various users are going to be permitted to leverage that FTZ that's operated by the 3PL. In many cases, there's also a landlord that's involved in owning the warehouse or the land on which the warehouse sits. So again, you can consolidate some of these entities in some cases, but it certainly adds a level of complexity where there are multiple parties involved, and you're trying to ensure that you meet the requirements for compliance. So, because the FTZs can't confer such a strong benefit, strict rules apply to govern how merchandise is admitted into a zone, and how inventory needs to be maintained within the zone. And then, of course, how it gets removed from the FTZ. And because of these strict burdens, in most cases, companies will end up hiring either a standalone FTE to manage the zone, or dedicating a substantial portion of a standing employee's current time to managing the zone. And in most cases, again, unless it's a very simple and straightforward operation, companies typically tend to hire or license inventory control and record keeping system software to manage how merchandise is flowing into and out of the zone. And again, if you're generating enough of a benefit, it's certainly worth the cost for the software and for the FTE. But I would say you should probably anticipate annual maintenance costs of a zone to run close to $100,000. Again, assuming you have the employee, the dedicated or at least half-time dedicated employee, and are using a third-party ICRS software. Again, I have seen clients that were able to do this on their own without the software, which certainly limits their maintenance costs. But there are always going to be some maintenance costs and certainly some setup costs. So sort of like FTZs, another opportunity I wanted to talk about briefly are bonded warehouses. So bonded warehouses are used by importers of record to delay duty and tax payments and are also used for the storage of goods that will ultimately be exported. So again, this is focused on the duty delay or deferral opportunity conferred by FTZs. But in this case, you don't have some of the other additional benefits conferred by FTZs. So you would just pay the harbor maintenance fee if it applies at the time goods are entered into the bonded warehouse. And then you would only pay MPF and duties due at the time goods are moved from the bonded warehouse into the United States. And if they're never entered in the United States because they're either destroyed or exported, then you would never pay duties on those goods. The other I didn't talk about this, but the nice thing about FTZs too is you could hypothetically leave goods in an FTZ indefinitely, whereas bonded warehouses limit you for up to 5 years from the date of importation. So bonded warehouses, while certainly beneficial, tend to be reserved for certain categories of goods where inventory will be sitting in the warehouse just for a certain amount of time and eventually imported or exported. And you're not processing anything, or you're not conducting any manufacturing or processing activities. You're simply looking for the cash flow benefit of not paying duties at the time of importation. Another opportunity for duty avoidance, and this actually also plays into the discussion around Chapter 98. Temporary importation bond essentially allows you to bring in goods that you know will only be in the US for a certain amount of time. And instead of paying duties on them and trying to get the duties back on the back end or failing to get the duties back on the back end, you can simply not pay duties and instead post a bond for twice the amount of duties that would be due. It requires fairly close coordination with your customs broker to make sure that the bond requirements are met and filed timely, and that the item that you brought in under a temporary bond is promptly exported before your permitted period expires. And the TIBs are at the end of you're allowed up to a year, though you can file for an extension of that year twice. So the maximum permitted time that a good imported under TIB can stay in the US is essentially 3 years. And if you were to fail to export that timely and provide the port of export with confirmation of the documents indicating that you met that time frame, there would be liquidated damages on against your bond. There are a limited number of categories of articles that are eligible for TIB, but it certainly can be a benefit if you look through that list and determine that your products are potentially eligible for TIB. I know we're getting short on time, so I'll run through drawback fairly quickly. But it too is an area of sufficient complexity, but can be very beneficial for companies that are prepared to meet the documentary requirement. So what is duty drawback? Duty drawback permits the refund of customs duties, including internal revenue taxes and certain fees, that were lawfully collected at the time of importation. The refund is provided at the time of exportation or destruction. And there are a number of categories of goods for which drawback is offered. It's offered for direct identification manufacturing, meaning if articles manufactured in the US use imported merchandise and are subsequently exported or destroyed, then you, the importer of the item that was incorporated into that manufactured item, can obtain a refund of up to 99% of the duties paid on the imported component. I think direct identification drawback, both for manufacturing or not, is fairly straightforward, right? The idea that you pay duties on something that came in and that eventually left, but there's also opportunities to get drawback on what's called substitution. So if both imported merchandise and any other merchandise of the same kind and quality, and in this case that means something that aligns at the 8-digit HTS US code level, are used to manufacture articles, then you can get drawback on the imported merchandise, even if you couldn't actually link that imported item to the item that was incorporated into the manufactured item that left. So if I bring in a widget that is identical to a domestic widget and I manufacture something in the US, even if the domestic widget is the one that went into the manufactured item that left the US, if I can correctly correlate and document the correlation between, or the comparability between the item that was imported and on which duties were paid and the item that was exported, you can still get a refund of up to 99% of those duties. More straightforward, if you import merchandise that is rejected because it doesn't conform to your specifications, you can get a refund once that rejected merchandise is exported or destroyed. Same with unused merchandise. Obviously, if you import merchandise not for manufacturing purposes, but for inventory, and it sits in inventory, and eventually you determine that you can't sell it in the US, if you can export it or destroy it, you can get a refund of the duties paid on that directly identifiable unused merchandise. And similar to the concept of substitution in manufacturing, if you can identify non-imported merchandise that is comparable to imported merchandise on which duties were paid, and that non-imported merchandise is destroyed or exported, you could potentially obtain a refund of the duties paid on the imported merchandise that is being substituted by the merchandise that's not imported. There are very specific procedures that need to be filed to pursue a drawback claim. Drawback offices are not in each port. They're really only in 4 ports: Chicago, Houston, Newark, and San Francisco. All of the documentation for a drawback claim needs to be filed within 5 years of the date of importation. And under new rules, all of this needs to be done electronically. And then all import or all relevant documentation needs to be retained on record for a period of at least 3 years following the date of export. So in addition to the document retention requirements associated with drawback, there are certain other opportunities that present challenges sometimes, and that is, oops. The importer who is seeking to rely on a basis for drawback, particularly in the manufacturing space, is often posed with the challenge of making sure that the manufacturing drawback claim either aligns with an existing manufacturing drawback ruling where CBP has imposed general guidelines for manufacturing that permit drawback. And if the proposed manufacturing process does not align with one of those general manufacturing rulings, the importer would actually have to or whoever was actually trying to file the drawback claim would have to approach CBP and get a specific manufacturing ruling, essentially verifying that the process they're proposing to take permits them to exercise or request a drawback claim on imported merchandise. There's also, an opportunity for new drawback claimants to look at retroactive claims. So because the drawback rules allow for a 5-year window from the date of importation, assuming you can put together the documentation, if you're year 3 of that 5-year window, you still have an opportunity to look at retroactive refunds, assuming you can put together a documentary chain showing a link between imported items or substituted items and exported items. And although under normal circumstances you have to file a prior notice with CBP that you intend to file a claim on exported merchandise, there's a one-time waiver of that prior notice. So if you're new to drawback and you're exploring historical or retroactive drawback, you want to make sure that you're gathering all possible claims into that initial, one-time prior notice waiver claim. And there are some additional opportunities there too. You can get accelerated payment if you apply for it. So bottom line is, duty drawback is an enormous topic that I could go on and on about. It can be a great benefit for importers who have gone through the exercise of looking at classification, valuation, origin, have determined that they cannot avoid the 301 tariffs or underlying duties, and have no other way of avoiding them, but they are exporting goods from the US, or there's for some reason a material share of the goods that are being destroyed. Those importers should certainly be looking at duty drawback as an opportunity to get refunds of tariffs and duties paid. And unlike FTZs, where it's not really a tool for avoiding 301, you can definitely get drawback on 301 duties or tariffs paid rather. So, even if you are not the exporter, there are ways to coordinate with the exporter and or transfer rights for drawback so that you can pursue jointly or separately refunds of tariffs paid. And again, I know I'm flying through some of these topics, so please, if you have detailed questions, reach out to me separately. And it looks like there is a question. Would you have any specific recommendations for a company that is forced to import fabric because fabric of such quality cannot be sourced within the US, and manufacturing all of its products within the US in terms of pursuing duty relief on fabric imported? Yeah, I mean, again, happy to look at this offline, but I think a number of the topics we've talked about today could potentially offer relief, either by reducing the value of the fabric paid at the time of importation and against which tariffs and duties would apply, or by, if you're exporting finished components, looking at drawback potentially. And then one final avenue for relief may be the last topic of the presentation, and it looks like we just have a minute, so I'll jump into that. As many of you probably know, there were a number of exclusions granted for the 301 tariffs, meaning that importers that requested an exclusion for their products did not have to pay 301 tariffs, and other importers whose products aligned with the description of the products in granted exclusions were entitled to avoid tariffs. All of those exclusions have expired. The USTR mid last year or mid to late last year opened up a potential opportunity for an extension of a specific number of those exclusions that are spread, as you can see in the slide, across all 4 lists. And a lot of comments were filed in support of this, and so it looks like we may get an opportunity in the coming months for importers who had benefited from these exclusions to benefit from them again. Again, this is only 549 exclusions, though that certainly applies to more products and importers than that number. And it does seem like there's an increasing amount of pressure by Congress and by certainly domestic industry or domestic importers to pursue opening up this exclusion opportunity even more, either by allowing all previously granted exclusions to be extended, or even by reopening the exclusion request portal and opportunity. So to that last question, and I know I'm running out of time, if you didn't find any classification, valuation, origin, FTZ, bonded warehouse, duty drawback, or other opportunities for mitigation, there may still be hope for you to either have your products fall within the confines of a previously granted and now extended 301 exclusion, or an opportunity potentially, though this probably wouldn't arise until late in the year, filing a novel exclusion request for your product. So with that, I know we're out of time, and I know I've glossed over a lot of these topics fairly quickly. Please feel free to reach out if you have individual questions, and I'd be happy to help.
Thank you, Matt. Can you hear me, Matt?
Yep.
Okay, great. Well, thank you, Matthew. We greatly appreciate your participation today, and thank everyone that is on the webinar today. As I mentioned earlier, we will be sending a recording later today. It'll come out, and the PowerPoint presentations will also be sent out later today separately in an email. I did want to just mention again that we are just opening registration for our March 9th and 10th forced labor webinar that will be running from 2 to 4 on both days. Registration is open as of now. We will have speakers from Customs, Biogen, attorneys from GDLSK, and Sandler, Travis, and Rosenberg, and Paula Conley will be moderating the session. So please check out our website at connect.org. Registration will be up. It is open right now under the events tab. So with that, I thank everyone for attending today. And again, thank you to Matthew for presenting and taking the time to put this all together. It was a great presentation. Thank you.
Thanks, everyone.